This is episode 326 of the Rio Grande Foundation's Tipping Point, New Mexico. I'm Paul Gesing, president of the Rio Grande Foundation, New Mexico's free market think tank. You can find out more about the foundation at riograndefoundation.org. I am very pleased to be joined this week by Timothy Sandefur. He is the head of the Goldwater Institute, and he is an attorney with the Goldwater Institute as well. Welcome to Tipping Point, New Mexico, Tim.
Thanks so much. I should correct you before my colleagues get too mad at me. I'm only the vice president of litigation at Goldwater. Our president, Victor Riches, is my boss.
Okay, my bad. For some reason I thought that you had taken the reins over there.
Someday,
all right.
Paul. Someday.
Someday. All right. Look out, Victor, vice president for litigation. I should have opened that window before I got to you. All right. Well, anyway, that sometimes you win, sometimes you lose, and we'll talk about losing in a few minutes. But we are going to talk a lot about the issue of donor privacy and organizations like the Rio Grande Foundation, the Goldwater Institute, and why we value donor privacy. As we get started here, Tim, why don't you share a little bit about Goldwater Institute itself and kind of our mutual concern about the issue of donor privacy.
Yeah, so the Goldwater Institute is a nonprofit organization, just like Rio Grande Foundation. We're headquartered in Phoenix, and we defend constitutional freedoms both in the courtroom and in legislatures and in the court of public opinion. So I'm primarily in charge of suing the government when it violates people's constitutional rights. But we also develop policy solutions and try to persuade lawmakers and the general public to respect the rights of people to own property, to buy and sell goods and services, and to respect freedom of speech and other constitutional rights.
Yeah, and you guys get a lot of publicity around the country, including from columnist George Will, who loves to, I don't know, maybe every couple of months talk about Goldwater and all the great work they do. And it's no lie, Goldwater is one of the standard bearers for the state free market movement.
Yeah, he's been very good to us, and we do try to represent. Senator Goldwater was very famous for standing for principle, even when it was unpopular, to the point where even people who very strongly disagree with him, and he didn't lie too long ago, so there's still many people in Arizona and beyond who remember Senator Goldwater personally. They all really respected him because he stood for principle, even if they disagreed with him. And that's the standard we aspire to live up to.
All right. Well, I definitely want to talk to you later on about some of the other great work that Goldwater is involved with, but let's get right to it on the issue of donor privacy. Why is this an issue for our organizations? Why is this relevant to average citizens, for example?
Yeah, well, there's lots of organizations like Goldwater and Rio Grande that survive on the money that is donated to us by individuals across the country who believe in the kind of work that we do. And these are people who believe in the rights of private property, free speech, economic liberty, and so forth, and who want to see a spokesperson or spokes group, I guess, out there defending the values that they believe in. And they often don't find anybody representing their views among politicians. And so they donate to organizations, think tanks that develop policy proposals or that go to court to defend individual rights for people who can't afford their own lawyers and things like that. And so they donate to these groups. Well, unfortunately, especially in recent years, we've seen a rise of people who devoted to stripping them of their privacy rights if they donate to groups like ours. These are people who claim that there's something undemocratic or something obnoxious about contributing your money to an organization that defends the values you believe in, whether it be, the NAACP or the ACLU or Planned Parenthood or the Cato Institute or the Goldwater Institute or Rio Grande Foundation. So these people often argue that there's something nefarious or undemocratic about it. And they've come up with a really clever slogan, dark money, which is supposed to indicate that there's something bad about donating your money to an organization that supports your political or social or economic views and articulates those in the marketplace. And so these groups have gone out there and passed laws to require you to put your name, address, employment information, phone number, and so forth on a publicly accessible government list whenever you donate to one of these organizations or whenever these organizations expresses a political opinion. And that violates freedom of speech, the bedrock principle that everybody should be allowed to articulate their views. Now, a lot of the time you hear people say, well, you shouldn't be out there articulating your views under anonymously, right? There's no free speech, freedom of anonymous speech. But in fact, the authors of the First Amendment themselves often spoke anonymously. The Federalist Papers were written under a pseudonym. It was commonplace at the time the Constitution was written for people to express their political views under a veil of an anonymity, precisely to avoid ad hominem attacks or the kind of retaliation and intimidation and harassment that can often follow if you strip people of their privacy when they endorse an unpopular political view. So of course the Constitution protects your right to contribute to an organization you believe in without being stripped of your privacy rights. But unfortunately, there's this campaign against privacy that's going on, particularly on the left today.
And just to be clear, the privacy issue is something that liberal groups and conservative groups benefit from. Although it seems these days that it's only the conservative side that is really fighting the fight, although sometimes liberal organizations also do engage in the fight for donor privacy, but kind of much more reluctantly. Is that your experience in recent years?
It certainly feels that way. I mean, this big Supreme Court case that was just decided, Americans for Prosperity versus Bonta. In that case, you had a very broad spectrum of both left and right saying that it was wrong for the state of California to try and strip donors of their privacy rights in that case. Unfortunately, that seems to be a rarity. It does appear that the left in particular is devoted to depriving people of their privacy rights if they donate to political causes that the left disagrees with. And the most striking example of this, of course, is the Proposition 8 campaign in California some years ago, when that was the anti-same-sex marriage initiative that passed in California and was later held to be unconstitutional. But while all of that was going on, the people who opposed Proposition 8 obtained the names and addresses of people who donated to the Yes on Proposition 8 campaign and posted those all over the internet, even making a Google Maps map of their home addresses, basically inviting people to engage in harassment, intimidation, vandalism, and even violence against people who supported this initiative campaign. And there were many cases of that. The Heritage Foundation documented the many cases of personal harassment and violence that occurred as a result of that kind of publicity. So unfortunately, it does seem as if the left in particular has in recent years been devoted to depriving people of their privacy rights if they support a cause that the left considers unacceptable.
Now, just to follow this through to its conclusion in the past, if you will, these kinds of donor privacy debates, to my knowledge, really got maybe their start, or at least got really into the courts when the NAACP wanted to have its freedom to keep donors private way back in the 1960s when it was dealing with the state of Alabama. And for obvious reasons, the NAACP at the time wanted to keep its donors private.
Yeah, that's right. There was a series of cases that involved the NAACP and similar organizations in the 50s and 60s when southern states passed laws forcing them to turn over the names and identities of their donors. And the Supreme Court in several cases in a row said that that's unconstitutional. Most famous of these is NAACP versus Alabama. That case, while that litigation was going on, the NAACP was basically out of business in Alabama for something like 6 or 7 years, if I remember right, because they refused to turn over that information. And the state said, oh, well, we need this information to make sure that you're following the tax laws of the state and everything. Well, we would know what was really going on. It was an attempt to sort of pin a badge on donors to these politically unpopular organizations in order to make them targets of harassment in the general public. And so the Supreme Court said that's unconstitutional. There was a similar case in Arkansas around the same time called Shelton versus Tucker, where the state passed a law saying that anybody who wants to be a public school teacher is required to turn over the names of any organizations that they donated to in the previous years, And the state promised, oh, well, we promise we're going to keep this information secret, right? We're going to put it in a safe and nobody will ever see it. But what the Supreme Court said was that's still not good enough, because the very fear that a person's going to experience in deciding whether to donate to an organization like that because they're afraid of future retaliation, that creates what lawyers call a chilling effect. And so we can't accept that chilling effect. We can't create an environment where people are afraid to express their opinions because of possible retaliation. And so this, again, in the Shelton case, the Supreme Court said that's unconstitutional. And those were the cases that the Supreme Court relied on just a few months ago in striking down a similar requirement in California.
All right. Well, let's fast forward to this current case, the Americans for Prosperity Supreme Court case. I'll make the editorial comment that while I think most folks on the right supported Amy Coney Barrett in her ascension to the court, we've been a bit disappointed, if you will, by the overall approach taken by the U.S. Supreme Court to a variety of issues. Now, when we talked, I don't know, a month or so ago on the phone about the AFP case, Americans for Prosperity case on donor privacy, and the decision that the court made, you seem to be a little bit disappointed in that. So talk about the issues, and then we can talk about the decision it was actually made and how effective or ineffective it'll be in the real world issue of donor privacy.
Yeah, well, the disappointment that I experienced was that I think that the case is a little bit narrower than it could have been. I had hoped that the court would make a very broad statement about donor privacy, and it didn't do so. Now, the Supreme Court usually tries to avoid making broad pronouncements, so it's not terribly surprising. It's just I wish that they had been clearer in that respect. So this case began 10 years ago when the Attorney General of California, who at that time was Kamala Harris, said that nonprofits doing business in California would have to turn over the unredacted versions of their IRS reports. Now, what that means is every year, a nonprofit is required to turn over certain paperwork to the government to make sure that they're following the tax laws, and they have to fill out paperwork with the IRS. And then California said, and you have to give us a copy of the IRS paperwork that you turn in. And in the past, these organizations had been allowed to delete, line out information about their top donors so that as to protect their privacy. Now, this didn't mean they were keeping anything secret, because the Attorney General could still get that information by just sending a subpoena or an audit or something like that. It's just that these organizations didn't want this information to be posted on the internet or something where somebody else might misuse that information. Well, unfortunately, when Kamala Harris said, no, we want you to turn over the unredacted copies of this information. Well, then she said, and just like in the Shelton case that I just mentioned, she said, oh, no, we promise we'll keep this secret. We won't disclose this information. Well, of course, it all got out. There are 2,000 instances of this information being publicized, according to a later court finding. So these organizations, AFP and Thomas More Law Center and the Institute for Free Speech, filed lawsuits challenging. Oh, and I should mention that the Goldwater Institute also received one of these demand letters, although we're proud to say we declined to turn over this information. But these organizations sued over these requirements. And, long story short, the Ninth Circuit said that they were okay. This requirement was perfectly fine. Now, what was it that Kamala Harris said was the reason for making this demand? That's important, because when the government restricts or burdens a person's free speech, it's only allowed to do that if it's doing something really important and if it's accomplishing that important thing in the right way. So the first question is, why is the government demanding this information? And her answer was, because it makes things easier. That's it, right? It's not like to prevent a nuclear war. It's not to prevent a forest fire. It's not to protect to enforce the tax laws. It's just because it makes things easier. They call that administrative efficiency. Well, that's about as bottom line as you can get when it comes to government interests, right? Government interests, there's a spectrum of highly important government interests like, national security. And then there's bottom level government interests, including this administrative efficiency requirement. So that's what she asserted. What the Supreme Court said was, well, you're demanding so much information to serve a relatively low important interest, this efficiency interest, that's not good enough. Now that's right. That's the right holding. The reason why I say is it's not as broad as I would like is because the court did not emphasize that how minor an interest that is, right? Administrative efficiency is not a very important interest. And I wish the court had gone further and said, that's such a low value interest that you're not allowed to do this at all for that purpose. Because the next time that there's a case about donor privacy, what's the likelihood that the state's going to say, oh, well, we only need this information because it makes life easier for us? They're not going to do that. Politicians always say that whatever they're doing is the most important thing ever, right? So that's what they're going to do next time. And that means that I don't think this case is going to set a tremendously important precedent.
Now, you probably have read through, the decision, and maybe even you heard or saw transcripts of the debates or the deliberations, I should say. It was a 6-3 decision, right?
Right.
By the court. So was this a case of there were 5 maybe justices who were a little more interested in a broader decision, but they were trying to go with a more consensus-based approach? I mean, I'm sure the 3 liberals were the ones saying, open it up, but I don't know, I guess, what does this decision mean for the future of donor privacy before this particular court?
Well, it's a helpful decision, but it's not really as good as it could have been. There's a couple issues that remain open. One of them is the issue that's at the heart of the case that you and I are involved in, the Rio Grande versus City of Santa Fe case, and that is when can the government demand this information when you're talking about a ballot initiative, right? Back in the 70s, we mentioned those civil rights era cases like the NAACP cases about donors to organizations. Well, in the 70s, the Supreme Court seems to kind of water down those NAACP cases when it issued a decision called Buckley versus Vallejo. And in Buckley, the court said, well, the government can require the disclosure of donor information when you're talking about donors to a political candidate, because there you have a risk of something like bribery or manipulation of the political system because some organization has a candidate in their pocket or something. And so it's legitimate for the government to force candidates to give out this information about who gave them money. Okay, fine. But what does that mean when you're talking about a ballot initiative? Right? A ballot initiative can't be corrupted or bribed because it's not a person, it's just a thing. So can you force people who side one way or the other on a ballot initiative to turn over their information? The Supreme Court has actually never answered that question, even though it came really close in a case called John Doe versus Reed a few years ago. So we were kind of hoping that the court in this case might say a word about that issue, and of course they did not. As for why they issued the kind of decision they did, well, there's a lot of judicial politics that does go on, and it's impossible to really tell what's happening. But it's also true that the court does try whenever it can to decide questions as narrowly as possible. So this case was an example of, not going as far as I wish it had, but that just means that there's going to have to be another case.
Well, there's at
And
least an
hopefully it's
outside.
ours.
Yeah, I was going to say that's a convenient segue there, Tim. Our case is at least possibly a case that could have determination in that regard, or could be heard by the Supreme Court. Folks who have listened to this podcast before are aware of our work, the Rio Grande Foundation's work in the Santa Fe soda tax issue a few years back. We wound up in some hot water, if you will, relating to the city of Santa Fe's, I believe it was $250 cap on any engagement in a readily identifiable ballot measure, and how we violated that, and then we've been in court. And I already had this podcast scheduled, so it was very good timing, I guess. If that's the only thing the court did for us, they
Right.
they produced a case in a hearing. A verdict, or God dang it, ruling. Sorry, I'm not a lawyer. I don't speak like you folk.
Same
but,
difference.
Yeah. So with all that butchering being said, they handed down with a ruling last week, relating to a case that you, Goldwater Institute, you personally were representing us on. So dive into that for us here.
Yeah, so this case, Rio Grande took a position on a ballot initiative, this stupid 2-cent soda tax in Santa Fe. And the city said, therefore, because you spent more than $250 to oppose this initiative, you're required to comply with our disclosure mandate. Now, what they said was that this video that Rio Grande did not make, but posted on its Facebook page, that it cost more than $250 to make that video. So therefore, Rio Grande was required to comply with this disclosure requirement. And the disclosure requirement is you have to turn over the names and information, employment information, and phone numbers, addresses, to a publicly accessible government list of any person who donated even a penny for that purpose. So if I donated $1 to Rio Grande Foundation because I'm opposed to this soda tax, now my name and information goes on this publicly accessible government list. And of course, that never comes down, right? Once something's on the internet, it's out there forever. So 20, 30 years from now, and when you retire, Paul, and you're replaced by some far left-wing socialist radical, and Rio Grande Foundation changes completely into being a collectivist organization that advocates seizing the means of production, now my information is still out there, and people are going to come after me because they think I donated to the communist version of Rio Grande, right? Well, that may sound silly, but that is entirely possible because these lists never go away. They're always publicized once they're on the internet. So that means donors to these organizations are always at risk for retaliation and harassment forever forward. So we sued over that and said that's unconstitutional, in violation of the First Amendment. And unfortunately, what the 10th Circuit Court of Appeals did in this case last week was it said there's no standing. Now, what standing is standing is a question of whether you're allowed to sue, right? Standing can sound complicated when lawyers use all sorts of jargon, but basically what standing boils down to is who are you to complain, right? So the question is, do you have a right to complain about this? And what the court said, no, you don't have the right to complain about this because you are still willing to speak. We had put in our brief that Rio Grande Foundation intends to speak in support or opposition to future ballot initiatives in New Mexico. Therefore, the court said, you don't have standing to sue over a restriction on your freedom of speech. Now, my view is that is illogical. That doesn't make any sense. Courts have said that if you say you're not going to speak out in the future, then you don't have standing. So, of course, we had to say, and it is accurate to say, that the foundation intends to take a position on political issues going forward in order to have standing. If Rio Grande had said we no longer intend to speak publicly, we would not have standing. So it does not make logical sense for the 10th Circuit to say that we don't have standing to challenge a restriction on our free speech because we intend to speak out. In fact, the courts have said, including this court, have said that a chilling effect on free speech, you can't prove the lack of a chilling effect just because some people are brave enough to continue speaking, right? A chilling effect is when people are afraid to speak out. They're intimidated that at the risk of retaliation or harassment, and so they're afraid to speak. Well, there's going to be some people out there who still have the guts to go out there and speak out, even though they're going to be harassed. So you can't prove that there's no chilling effect simply because some people continue to express themselves. Yet that's what the 10th Circuit said. The 10th Circuit said you don't have standing to sue over this thing because you're willing to speak out still. That's not logical. And so we're going to ask the court to reconsider the case. And then if they decline to do so, we, of course, will ask the Supreme Court to take up the case.
That just seems like bizarre reasoning. Any idea what they were thinking with regard to that? Because yeah, it's almost like saying that there's a mask mandate in place to take a current issue, and because you defy the mask mandate and then sue whatever institution like the university you're potentially going to, and they say, well, you don't have standing because you're not wearing a mask anyway. It's bizarre logic in my humble opinion. But again, Thankfully, I'm not a lawyer.
The first thing that came to my mind was I did a case many years ago now in Nevada challenging the constitutionality of a law that imposed a licensing requirement on private investigators. And it defined the concept of private investigator very broadly, so broadly that if you wrote a biography of Thomas Jefferson, you were technically a private investigator under this law. So we sued and said that that violated First Amendment rights. You're not allowed to say that people are not allowed to speak until they have government licensing, right? So we sued over that. And the court threw the case out because we said in our brief that we were complying with the law because my client was not practicing private investigation in Nevada because he was afraid of being punished because he didn't have a license. And the court said, well, then you don't have standing to sue because you have not said that you intend to practice private investigation. Well, here we did the exact opposite. We said we do intend to continue speaking and we still don't have standing. That doesn't make sense at all. So that's why we're going to ask the court to reconsider that ruling. And as I said, go to the Supreme Court if we have to.
All right. Well, I want to talk to you a bit about Arizona politics and policies because we are neighbors after all, even if Arizona is light years ahead of us in terms of its public policies. But I'm going to throw you a bit of a curveball here because I'm, as I said, and I will continue to say, not a lawyer, but you watch these things, you see these courts come up with their rulings, and it just strikes me as the judiciary in this country is increasingly political in terms of they don't read the rules based on the written word. They tend to, by and large, and I think this is mostly true of liberal justices. You can argue that maybe sometimes it happens on the right, but I'd be interested in your input on that. So it just seems like these judges have made up their mind more often than not and want to make a decision that fits in with their beliefs on any given issue, as opposed to reading the law as it's written. Talk about that because it's something I think a lot of people are frustrated with.
Well, it certainly does happen. I think it's a very complicated issue for a couple of reasons. One is that when you're a lawyer, of course, your job is to formulate and weigh arguments and to interpret written words. And if you have certain preconceptions about justice or what individual rights are, that's going to affect how you interpret words. And so it doesn't necessarily mean that a judge is in bad faith if the judge reads a statute and comes out with a view that's consistent with that judge's political views, because both of those things affect each other. How you understand the law affects your politics, and how you understand politics affects your understanding of the law. They go back and forth. I mean, I know that I was drawn to study the Constitution because I was, to begin with, a classical liberal. I believed in private property rights and free enterprise and free speech and these things. And so when I learned about the Constitution in college, I was really drawn to that. And that's why I chose to pursue this career. So my politics influenced how my understanding of the law, and the law influenced my politics. So it's not quite as simple as saying, well, judges are just political. But it is also true that sometimes judges really are just politically driven, and you can't explain that in any other way. On the other hand, there's another phenomenon. A lot of the time, people use the term judicial restraint or judicial activism. And I really don't like those terms because a lot of the time, what we call restraint is actually political. A good example of that is the infamous Kelo versus New London private property rights case, the eminent domain case from 2005. Now there you had the government taking away a person's house and tearing it down and building luxury condominiums on it. And the question was, is that constitutional? And the Fifth Amendment says the government can take private property for public use. Now, we can debate what public use means, but one thing that ought to be crystal clear is it does not mean private use, right? That's the only thing that's absolutely unambiguous about the Fifth Amendment. And yet, when you get to the Supreme Court, Justice Stevens and his 4 liberal colleagues held that it was constitutional to take away this woman's house and turn it over to a private developer for private profit because economic development is a public use. Why? Justice Stevens never actually tells us why. He says it's a traditional and long accepted function of government. Doesn't even give us a footnote to explain where he gets that idea. Where does he get that idea? From his politics, right? Now, Kelo was a judicial restraint case. That's not act. I mean, that's not the court over enforcing something. That's the court refusing to enforce something, refusing to enforce the Fifth Amendment because of politics. So restraint can be just as political as activism. So I tend to shy away from those terms. So the bottom line, to answer to your question, is yes, of course, judges are definitely affected by politics. Sometimes they're very partisan, but it's also true that sometimes it's a little more subtle than that. Sometimes, it's a question of values, and that's why, the controversies over who gets put on the Supreme Court are so important, and why a lot of states have judges can be, recalled, like they were like in California when I was young. So, there's all sorts of checks and balances in place because as human beings, all political figures, whether it's governors, legislators, or judges, being human beings, are going to be affected by their own political views.
Yeah, and just for the record here, Kelo versus New London. By the way, Tim, that's the one and only Supreme Court case hearing I ever have gotten to listen to in person
Oh,
in
yeah.
my life. I was in the D.C. area still at the time, and the majority was Stevens, Kennedy, Souter, Ginsburg, and Breyer. I wonder how many of those RBG fans fawning over her and when she passed away, just loving on her, really looked into the Kelo versus New London decision. But anyway, the dissent was O'Connor, Rehnquist, Scalia, and Thomas. So it's Scalia and Thomas tend to be on the right side of those issues. Finally, before I leave the whole judiciary alone, who's your favorite current Supreme Court justice, Tim?
I think it's probably Gorsuch. For a long time, it was Justice Thomas, but Justice Thomas there are some things I think he's wrong about. And one of the big ones is the meaning of the due process clause of the 14th Amendment. Justice Thomas has a very narrow understanding of what the 14th Amendment's due process clause is. Whereas Justice Gorsuch, I think, has a view that's closer to the truth. Now, I get more into this in, I'll plug my book, shamelessly
Sure.
plug my book. I get more into this in my book, The Conscience of the Constitution, where I discuss the due process clause. Now, that was written before Justice Gorsuch joined the court, but he appears to me to take a view much closer to my own. So, that's not to say I've rejected Justice Thomas entirely. I find him a fascinating writer, and I really enjoy when the two of them disagree. And there have been several cases in recent years where Thomas and Gorsuch have been opposite sides. And it is just fascinating to read their back and forth because they're both such brilliant men and their writing is so good that there are times when it is very hard to say which side I fall down on.
Yeah. All right. Well, we'll leave that alone for now, at least. And, Goldwater is a think tank based in the state of Arizona. And I know in particular that you all have been very active on the issue of educational choice and education reform, and that is something that's happening all over the country. And I know you're not a policy guy. I screwed up and thought you were the head honcho at the beginning, so you might have had more of a grasp on everything if you were the head honcho. But I'm confident you can talk a little bit about what's going on in Arizona public policy, both school choice, education reform, or economic rules and regulations.
Well, we are very proud of our advocacy on behalf of school choice. We think that every parent has the fundamental right to decide how their child is going to be educated, and in particular, to know what their children are being taught when they do send them to a government-run school. And this has become very controversial in just the past year or so because of the increase in attention being paid to critical race theory in the classroom. So the Institute has been out there working in favor of transparency, rules that require schools to tell people what it is they're teaching their children in classrooms that their tax dollars pay for. And unfortunately, there's been quite a lot of pushback by education bureaucrats across the country on this score. We have taken up the case of a woman named Nicole Solis, who is a parent in Rhode Island, who asked for information about what was being taught in her local public schools to her child. And the school refused to turn this information over unless she filed a formal whatever that state's version of the Freedom of Information Act. That's what they demanded. You have to file a formal FOIA request. So she submitted that, and the schools came back at her with a demand for tens of thousands of dollars in payment in exchange for this information. So we went to court over this. And just last week, the National Education Association filed suit against her for seeking information about what is being taught in her public schools that her tax dollars pay for to her children. And that's just outrageous. We believe that every parent has a right to this information, and that every state should require that this information, the curriculum that's being taught in the classroom, the classroom materials, be posted on a website where parents can access information and find out what is being taught to their children. And of course, parents should also have the right to decide to send their children to schools of their choice. Children, as the Supreme Court told us almost a century ago, children are not creatures of the state. They do not belong to the government. They are not a resource for the government to take into its own custody and educate for the benefit of the state. Children are human beings like you and me. They are citizens with constitutional rights. Their parents are the ones in the best position to look out for their best interests, and the state should respect the right of a parent to the upbringing of their children. And that is something that the Supreme Court has also made clear. So we have worked very hard to broaden the opportunities for parents seeking the right of school choice.
Yeah, and Arizona has been a real leader. Unfortunately, not so much here in New Mexico. We've been governed by people who kowtow to the unions, and it's incredibly frustrating and challenging. But if we ever get the chance to actually get some reformers in there, I promise you, Arizona will be the first state we look to for reform ideas and successes.
Yeah, I mean, it's funny. I'm glad you say that, because honestly, sometimes it's a little disheartening here in Arizona to see, because there's so much that we'd like to do. And compared to what we envision as the ideal, where every parent has the right to decide where to send their children, and we see how much resistance we get in Arizona, I guess the grass is always greener on the other side of the fence.
Oh, it's well, all drought and other issues aside, when it comes to all manner of economic policies, Arizona's grass is pretty darn green, certainly
That is
compared to New
true.
Mexico.
That is true. We have been counting our blessings here recently, especially in the past year and a half, because of the shutdowns and things. Compared to some of the other states, we have really had a much more mild approach that I think, there's some things I disagree with, of course, but I think our government in Arizona has done a relatively good job of balancing the needs of public safety with the need for an economy that is free and open enough to adapt to the new environment that we're all going to have to live in.
Yeah, no, good work out there in Arizona. Doesn't mean it's you can wrap up the sidewalk and leave on a long vacation. But
Darn, I was just planning to.
I know. So last thing, I know school choice and education reform are near and dear to your hearts at Goldwater, but I'm hoping you can at least comment for me on. I'm looking at an article relating to a lawsuit seeking to block efforts to put Governor Ducey's tax cuts on the ballot. This is from the Arizona Republic, July 22nd. So it's a pretty new article. Can you at least run us through some of the issues going on with regard to tax policy in Arizona and its importance?
Yeah, in fact, that's what I'm going to be working on as soon as I'm done talking with you here. So what happened was the legislature passed a very, very beneficial tax cut in Arizona that, and by the way, this comes in the wake of a huge tax increase that was recently passed. That's also a lawsuit. I'll talk about that in a second. But this tax reduction was then challenged in an effort to put it on the ballot in a referendum. Arizona allows voters to have a referendum over anything that the legislature passes, but there are limits on that power of referendum, including a rule in our Constitution that prohibits any referendum of legislation that's necessary for the funding of government departments. Well, of course, a tax bill is necessary for the funding of government departments. So that question over whether that can be put on the referendum ballot, that question is now has the subject of a lawsuit that was just very recently filed. And actually, we're having a meeting shortly to discuss how we're going to approach that case. Now, the second thing I mentioned about the tax increase that's also in front of the court, well, that case is about this enormous tax increase that's called the Invest in Ed initiative that raises the taxes in Arizona to create a special fund for schools, for government-run schools. And it violates all sorts of constitutional restrictions, including restrictions on spending that exist in our Constitution. And what's amazing about it is the initiative says, this is not a constitutional amendment. This is just an ordinary law that gets passed by the voters. But it says in there, the revenues from this initiative shall not count as expenditures for purposes of the Arizona Constitution. Well, you can't do that. You can't pass a law that claims that it's exempt from the Constitution, right? You can't just say, oh, well, that Constitution thing, this law doesn't have to follow that. So we challenged that, and we are now waiting for a decision from the Arizona Supreme Court. Actually, we argued that case in April. And I'm sorry that it's taken this long, but we're still waiting for a decision on whether it's constitutional for a tax increase to just exempt itself from the Arizona Constitution.
Wow, very interesting. And that's one of the other big differences between Arizona and New Mexico is your plethora of citizen initiatives and referenda on the ballot.
There's a reason for that, Paul. One of them is that Arizona's Constitution has this very unusual provision in it called the Voter Protection Act. Well, which is a misnomer if ever there was one, because what this law does is it says if something gets passed by the voters, it more or less can never be repealed. The legislature has to pass any kind of an amendment to it. It has to pass by 3/4, and it has to further the purpose of the initiative. What that means is that even if a ballot initiative is not a constitutional amendment, it still becomes more or less exempt from repeal by the state legislature. The only way you can repeal it is by another ballot initiative. So it sort of makes every ballot initiative part of the Constitution, even if it's not part of the Constitution. It's a very strange provision, but it's very popular among initiative supporters because once something gets adopted, it's like it's locked into place. You can never undo it, even if circumstances change. So this tax increase that I mentioned is not indexed for inflation, for example. So it gets passed, it gets locked into place by the Voter Protection Act, and it can't be changed in the future. So that's the kind of shenanigans that unfortunately is caused by certain poorly thought out provisions of Arizona law.
Wow, interesting stuff. Well, how can people find out more about your organization? And I know you've written a couple of different books. So anything you want to share briefly about how people might get a hold of those would be great.
Sure. You can find those on Amazon or Barnes & Noble or anyway, just search for my name. My most recent book was a biography of the scientist and philosopher Jacob Bronowski. And before that, a book about the abolitionist thinker Frederick Douglass. You can find out more information about the Goldwater Institute at goldwaterinstitute.org. And we have a blog. It's called In Defense of Liberty. And the address for that is indefenseofliberty.blog.
All right. Excellent. Thank you very much for your time today. Thanks for representing us in court. Onward to SCOTUS, as they say. And
that's right.
Hopefully that something will shake loose. It's about time. It would seem like maybe the Supreme Court is engaged in some kind of permanent employment initiative where they only decide cases halfway, knowing that there's going to be pushback or even direct contravention of their decisions. And I'm not going to get into it, but I'm talking about the Biden moratorium on evictions is one of them, in addition to all the things that we've been talking about. So it's frustrating to watch these folks in action. But all right, well, we'll leave it there. Thanks for listening to this week's episode. Find all episodes at tippingpointnm.com or at the Rio Grande Foundation's YouTube channel. Subscribe to this show at Apple, Stitcher, or have your Google Home play Tipping Point New Mexico. Thanks to Path 3 Marketing for producing this show.